Okay, let's go ahead and get started.
Okay, again, Your Honor, this is Carl Stern. I'm affiliated with both the Houston and Dallas offices of Quinn Emanuel. I'd like to start this morning, and I know you're aware of a lot of this, but I want to start with who we are. We represent plaintiff Arm Energy Management, which we'll refer to as ARM or AM throughout this proceeding. And ARM is an energy marketing company that was founded by two energy veterans in the energy marketing and trading business, and is now owned by them and the employees of the company. The company manages logistics, helping independent oil and gas producers get oil to market. We are in every major oil and gas basin in the United States, and we lease capacity on transportation and storage infrastructure from midstream companies, and we buy crude from producers. We don't charge a fee for the services that we provide to producers. ARM earns money by harvesting option value, and that's a concept we'll be talking about with some of our witnesses. And what that basically means is the company enters into a number of different arrangements that give it options for shipping crude. And for example, there may be a price difference between where it buys the crude and where it can transport the crude on available capacity. And so it can make money by doing that shipping. It can also put, for example, oil into storage because prices are low at the current time, and they think that the cost of storing will be offset, and they can earn money by selling the oil later. But you will hear there are a multitude of options that are embedded in the kinds of transactions that the company enters into. Now, as you know, on the this case involves two contracts between ARM Energy and Medallion Midstream. Medallion Midstream is a midstream company that actually owns midstream assets for gathering oil in the field on a web of pipelines. They own processing facilities, they own pipeline capacity for long haul of oil, and they also have access to storage facilities. Unlike ARM, they actually charge a fee for their services as opposed to trying to earn money on optionality. Medallion is owned by one of the largest private equity firms out of New York, and it is controlled by this private equity firm, which is called Global Infrastructure Partners. Its board is dominated by Global Infrastructure, and it receives its direction from Global Infrastructure. And like most private equity companies, its objectives are to extract as much cash as they can out of their portfolio companies like Medallion. Now, the two contracts at issue, again, as you know, Your Honor, involve transportation on this EPIC crude pipeline from West Texas to Corpus Christi, and a terminal services agreement relating to accessing this terminal in Corpus Christi, also owned by EPIC, for shipping oil overseas to overseas markets. Something that you'll be hearing about is this EPIC pipeline was built to target emerging markets or fields in West Texas that produced West Texas intermediate crude, which is refined largely in the United States, and West Texas intermediate light, which we call WTL, which is largely sold in international markets. Medallion didn't own this pipeline capacity. It leased the capacity from EPIC. It also leased the terminal from EPIC. It had no need for it itself, so it went out and tried to market it to third parties, and that ended up being ARM. Now, this case involves two important obligations that Medallion assumed under these agreements. One, Medallion was obligated to give ARM the ability to ship 27,778 barrels per day of either WTI, West Texas Intermediate, or WTL to Corpus Christi on the EPIC crude pipeline. Second, Medallion was obligated to give ARM the ability to load a Suezmax-sized ocean-going vessel at EPIC's crude terminal facilities in Corpus for the export to international markets. Now, these key obligations were important to ARM's decision to enter into these agreements. Here's ARM's business thesis. It was going to primarily focus on exporting WTL to foreign markets where WTL is more valuable. WTL normally sells for much less than WTI in the Permian Basin, but it can sold internationally at higher prices. And shipping on larger vessels is not only less costly, but the larger Suezmax vessel was necessary to handle the volumes that ARM was required to take under the contract. And there's a lot of optionality that ARM was intent on harvesting out of these arrangements. It could sell crude in Corpus Christi if exporting was not as profitable. It could store WTI or WTL for sale later. It could sell pipeline or terminal capacity to another party. It could ship nothing on EPIC and divert crude to other areas where pricing was better. And ARM's plans were rooted in U.S. public policy. Here's a quote from an Aspen Institute white paper in 2014. The reason for allowing exports is primarily that not all oil is the same. Most of the increased production in recent years has been in the form of lighter sweet crude. Unfortunately, this type of oil is not well suited for U.S. refineries. Economically, then, it makes more sense to export crude oil to Europe and Asia, where more refineries are configured to handle light crude. Light oil sells at a premium compared to heavier oil in world markets. In the United States, however, the refinery mismatch means that light oil sells at a significant discount relative to heavier imported oil. And it was this mismatch in pricing and refining capacity that prompted President Obama to lift the United States crude export ban in 2015. So here's why we're here. First of all, as we noted, ARM was entitled to a Suezmax vessel, and Medallion would not load a Suezmax vessel for ARM. The promised Suezmax dock, in fact, was never even built. Breach number two, Medallion was required to transport WTI or WTL at ARM's option, and Medallion would not transport WTL. It refused to do it. Now, the breach of either one of these agreements entitles ARM to terminate both. There's a cross-default provision in the agreements. ARM fully performed. Medallion did not. ARM paid $32 million in prepayments and credit support. Plus, before termination of the contract, it paid everything that was required with respect to the cost of transporting the oil and the terminal fees. Despite ARM timely making all the required payments, as I noted, Medallion never provided Suezmax service and never provided WTL. So what did ARM do? ARM terminated the contract. And under those agreements, Medallion was required to return the prepayments because the contract was ending and there was no need, there was nothing to prepay. So Medallion was required to return the prepayments, and it was required to release the credit support in the form of a letter of credit. Medallion refused to do this, and it kept ARM's money. It used that money to pay down a revolving debt, saving $50,000 in interest every month, and making it possible for Medallion to pay its private equity sponsor a $25 million dividend. So what we want $47.2 million in damages. It's comprised of $32.7 million in prepayments and credit support that Medallion kept. We want the return of $10.6 million in monthly shipping charges, less the value that we received. We want prejudgment interest of $3.9 million and attorney's fees to be determined post-trial. And now I'll pass it to Ms. Shee, who will jump into some of the details.
And Your Honor, you did mention that you were, you'd read up on this. So if at any point I'm kind of getting bogged down, please tell me and I can skip forward. But fundamentally, this is a simple story from ARM's perspective. It really is as simple as ABC. There were agreements for Suezmax and WTL service, and everybody concerned at the time understood exactly what those agreements meant. There was a breach. Medallion broke its promise to provide those services and actually admitted at the time that it was in performance default. And after ARM gave notice, it canceled the contracts, as it had every right to do. And I want to talk first about the agreements. And as Mr. Stern mentioned, this concerned capacity that Medallion received from Epic under a capacity swap that Medallion decided it needed to sublease to somebody because it had no use for it. Now, ARM turned out to be the sublessor, and just so you can see how the transactions worked, Epic did a 30-year lease to Medallion at $0 per barrel in April of 2019. In July of 2019, Medallion turned around and subleased that space to ARM for $1.50 per barrel. And the agreements with ARM are memorialized in two different contracts: a transportation agreement, and that contains the WTL promise, and a terminal agreement, which contains the Suezmax promise. And in total, under both agreements, ARM was required to pay $1.50 per barrel on what's called a shipper pay basis, meaning that ARM has to pay that charge whether it ships or not. And the total was 27,778 barrels per day, which works out to about 850,000 barrels per month. Now, this is a really important point for this case. The Epic capacity that was the subject of the agreements was under construction when they were signed. The pipeline was being built. There were two terminals underway. There was an initial terminal that was being retrofitted. It used to be a grain terminal. And there was a new terminal being built right next door. But when these agreements were entered, it was based on representations from Medallion and from Epic about what this infrastructure was going to be capable of doing. And the parties were working with a set of assumptions about what was going to happen. Now, also before the agreements got going, ARM partnered with a company called Glencore to use the agreements. And Glencore is an international shipping expert who was supposed to help ARM, monetize, the value of this deal abroad. Glencore had lots of contacts in the shipping industry and international refineries. So the key terms of this agreement included that both parties, ARM and Glencore, would source crude from the Permian. ARM would reimburse Glencore for all the shipper pay payments. So even though Glencore was coming in the picture, ARM was still going to be paying all the shipper pay payments. And Glencore would use its expertise and connections to find deals for these barrels abroad. And they would split the profits from the venture 40-60. Now, I want to talk about the specific promise that Medallion made regarding the Suezmax, and you find it in section 3.4 of the terminal agreement. It comes in three parts. The first part of this promise talks about what ARM is entitled to do. It is entitled to nominate on a firm basis, meaning not subject.
So this is one of the areas I had kind of a question.
Sure.
Is the 3.4A says a capacity of not more than 1 million barrels of crude. Why is plaintiff, I guess, taking the position that obligated Medallion to provide Suezmax if it was, because Suezmax is 1 million or more, right?
No, a Suezmax is a million capacity vessel. And the next vessel size down is an Aframax, which only holds about 750,000. So in order to, and it is ARM's entitlement to nominate and load this vessel. And I think, when I think about it from the standpoint of a parent, you tell your kids, you can take no more than 3 pieces of candy. That is, you just entitle your kid to take 3 pieces. If you then smack your kid's hand if they take 1, then that's not what was conveyed. When we use the term not more than, it means, there is an entitlement to do something up to that number.
Yeah, I guess that's not how I read it, but go ahead.
there's another analogy I might think of, an insurance policy, and we put this in our summary judgment briefing. And the insurance policy says that the policy is capped at not more than $25,000 per occurrence. In that case, the insurance company can't get out of their promise by telling you, well, gosh, we've paid $2 on your policy, we've satisfied our obligation. And here again, the way Medallion wants to read this, if it's not more than 1 million barrels, if that means that Medallion gets the option to give us whatever terminal they want to give us, they could give us a two barrel vessel. They could give us a 2-barrel capacity vessel or a 0-barrel capacity vessel. I mean, the only way to read this provision that doesn't render the contract illusory is to read it to say that it's ARM's option to nominate not more than 1 million, but under that 1 million, it's ARM's option in that range.
But a Suezmax is 1 million.
Correct.
Okay.
A capacity of not more than 1 million barrels. The Suezmax has a capacity of 1 million barrels. And this provision means you can bring a Suezmax in there. You can bring an Aframax in there if you want to bring a smaller vessel, but up to a capacity with not more than 1 million barrels would let you bring in up to a Suezmax.
Okay.
So that first clause talks about, the fact that ARM is entitled to nominate a vessel each month. The second part provides that it is for the marine loading of crude petroleum at either the initial terminal or the new terminal. And the final part, and we just talked about this, talks about what kind of vessel ARM is entitled to nominate each month. And it is a vessel with a capacity of not more than 1 million barrels of crude. And there is an agreement, the parties are in agreement that a vessel with a capacity of 1 million barrels is a Suezmax. Your Honor, do you have any more questions about that provision?
Not at this time. You can proceed.
In negotiations, Medallion promised Suezmax service. This is a term sheet that Medallion sent us fresh off of executing their transaction with Epic. It said in several places, no additional fees for deliveries to the following destination points. And they talked about the initial and the new dock as both being Suez capable. And they said it again in this term sheet. Firm loading windows. ARM shall receive 1 firm loading window per month at the initial dock and the new dock, and these would be Suez loading windows. This is what was offered. And Medallion knew that Suez service was highly material when it brokered its own deal with Epic. Originally, it was just supposed to get an Aframax, 750,000 barrels. However, Medallion realized that because it was going to be sending 850,000 barrels down the pipe each month, it needed a bigger vessel, or it was going to have this mismatch. As they say here, it will put us in a position where we've got too many barrels at Robstown, where the terminal is, relative to what we were able to load out. And so Medallion specifically asked Epic, could I have a Suez, 1 million, and I'll just buy the excess barrels at Robstown to fill my ship so I can clear out all the barrels by end of each month? And Epic said, yes, we're okay giving you guys the Suez window. And in fact, Medallion turned around and wrote to GIP and said this was a good get because it solved a mismatch they were otherwise going to have with the volumes. And this just graphically shows you the problem. If you have 850,000 barrels coming in each day or each month, but you can only load a 750,000 barrel vessel, then you're going to have 100,000 barrels each month you need to find a home for. And there are always going to be extra costs involved with that. You're going to have pump over fees to a different terminal. You may need to charter a different vessel. You may have to sell at distressed prices. And this really adds up. It really changes the economics of the deal, as Medallion itself acknowledged when it was brokering its own deal with Epic. Now, the Suezmax promise is not in our heads. If you look at this Medallion board consent to get into the agreement with ARM, and you look at the key terms appended to this consent, first of all, one of the key terms is back-to-back with Medallion's agreement with Epic. And you just saw Medallion bartered for its own Suez from Epic. Back-to-back means it turned around and promised it to us. Also, services to ARM include, without limitation, provision of 1 firm basis loading vessel per month of crude up to 1 million barrels at Epic's terminal. Again, this is Medallion's own board talking about the deal that is about to authorize with ARM. And it is clearly acknowledging that it is back to back, it's giving that Suez they got from Epic, and they're going to give it to ARM. And Medallion's lead negotiator said in deposition, I asked him, when you were negotiating with ARM, did you believe that you were offering a terminal that could accommodate a Suezmax vessel? And he said, yeah, when we were negotiating with ARM and with Epic, I personally understood at some point that we would be able to load a Suezmax. And we both had hoped that we would be able to get 1 million barrels onto that vessel. And I mean, look at what their CEO said. We deposed him too. And he acknowledged that the agreement between Epic and Medallion stated that the dock would be capable of docking a vessel like a Suezmax. And he said, okay, what does that mean for ARM? And he agreed. They would receive a loading window at the Epic terminal for a vessel up to 1 million barrels. This is their CEO, their lead negotiator, their board. Everybody understood that this promise was for a Suezmax. And unless you have any other questions about that, I want to talk about the WTL service.
Go ahead.
Okay. This is found in the transportation agreement. And the transportation agreement defines crude petroleum as crude oil meeting the specifications established in the tariff. And tariff is defined as the Medallion tariff. So let's look at the Medallion tariff. And by the way, Your Honor probably already knows this, but this was part of my education process for this. A tariff is basically like a 10K filing, but with the FERC. I mean, there are profound implications. You need to be truthful in what you put in this document. So the Medallion tariff said that it would accept crude petroleum for transportation under Epic's Common Stream 2, Common Stream 1, and Common Stream 2 from Epic origin points. So it's pointing to Permian Common Stream 2 and Epic. So I want to look at Epic's tariff. And Epic's tariff lists Permian Common Stream 2 as going as a product that can be shipped from groups 1 to 3, and we'll talk about those groups in a minute, with an API gravity of 44.1 to 50. And there's no dispute between the parties that that product is WTL. And with these group 1 are origin points, that's where oil gets on the pipe. Group 3 is destination points, that's where oil comes off the pipe. And there are a bunch of them. In the Epic rates tariff, there is a whole list of group 1 origin points where you're supposed to be able to put in WTL. And you can see that this long list of origin points corresponds to a number of different terminals within the Permian Basin. Now, again, just like with the Suezmax in negotiations, this is what Medallion promised. They promised 2 quality specifications, WTI and WTI light. This is the term sheet they sent us right after they executed their transaction with Epic. And Medallion went on to tell FERC, this is important, you have to deal truthfully with FERC, that they were going to provide WTL service. They said that, and this is an open season notice they filed before doing a deal with ARM. They said that the tariff will provide for a WTI and WTI light common stream. And Medallion also acknowledged the materiality of WTL service to ARM. In fact, when they first entered an agreement with Epic, they didn't have WTL service. But when they started negotiating with ARM, they quickly realized that they had to have this product or ARM wasn't going to do the deal. And if you look at this bottom email, this is Mr. Lastman again, the chief negotiator. He writes, I was panicking about it because that was a big point. I knew ARM wouldn't pay us the $1.50 unless they got a WTI and a WTI light stream. And so he said it was a miss on my part with respect to Epic. So I called them and got them to amend the streams under the lease to add WTL. Medallion knew this was so important to ARM, and then ARM wouldn't have done the deal without it, that it went back and specifically bargained for those rights from Epic. And here's just one final point about both the Suezmax and WTL promises, because you are going to hear a lot of argument from Medallion about how, well, Epic didn't do these things, so how was Medallion supposed to perform? Well, Medallion acknowledged to ARM, and this is legally correct, that we are responsible for Epic's performance, non-performance, because based on the ARM TSA that refers to the transportation and terminal agreements, their failure is our failure. We have to provide the services. And if we can't provide the services if Epic fails to. And just this is a really important point. As you hear the evidence in this case, anytime you hear about an epic failure, and to be clear, there were epic failures in this case, it is a Medallion failure. Medallion bound itself under these agreements to be liable to ARM for Suezmax and WTL service. And that covers the agreements. Unless Your Honor has any questions, I'll move on to the breach.
In your, my recollection is in your papers you submitted to me that there's a footnote on an addendum, I think, that talks about how WT or WT Light or whatever you call it was no longer required to be shipped or something. What is that footnote about?
Yes, Your Honor. And that footnote did not come about until about 8 months after the contracts had gotten going. So first of all, there's 8 months where that footnote doesn't exist. There's literally no excuse for not providing WTL service. And then
you guys didn't even request to use the pipelines for WTL until January after this agreement started, right?
That's actually not true, Your Honor. And
Okay.
this involves the way this, and it's because we kept being told that the service wasn't available. The way this industry works is you need to go out and source a product to put on the pipeline, and there's about a 2-month lead time. So if someone tells you in April that we don't have WTL service now, you're not going to go out and buy those barrels until you know that service is going to be available. Because if not, you've spent millions of dollars buying a product, and then you have to scramble to find a way to ship it. And so you have to, and honestly, like last minute service on a pipeline is much more costly than the shipper pay here. It was, and Texas law has a doctrine about futility that, if doing something would be just performative, completely useless ceremony, and then you're not required to do it. And here Medallion was repeatedly telling us, do not nominate this product. We will not take it.
Okay.
And we'll talk about this a bit in breach. On the topic of the Suezmax, we got going, there was no Suezmax stock available. And here's the first example on the WTL. We got an email from Epic. The performance under the contract started April 1st of 2020. And we got an email from Epic stating that due to changed circumstances, Epic Crude Pipeline no longer intends to offer WTL service under Permian Common Streams 2. And we were a little surprised by that because that was the key deal point. And so we forwarded this to Medallion and we said, wanted to check if you received it below and he had any thoughts about it. And Medallion said, well, the problem is they don't have much WTL right now, but they said it's going to get fixed, estimated June 1st. So right there, we're not going to go out and buy product until they say that service is going to be available, because it's just going to be baking in a massive loss. Now, unfortunately, the Suezmax stock got pushed back and the WTL got pushed back, but we're 6 months into the contract in October of 2020, 6 months in, and none of this has been cured. And so ARM gave written notice of Medallion's breaches on October 5th of 2020. And this is a 5-page letter. It's pretty detailed, but I'm just going to show you the key parts. On the Suezmax, we said that Medallion is in violation of its obligations to offer a marine vessel up to 1 million barrels on a firm basis per month as of the commencement date, and that the inability to provide the marine services is a material violation. And those words are super important, material violation of the terminal services agreement. On the WTL point, we said that we had concerns that we had not been permitted to deliver that product. And this is really critical, we said that we asked that Medallion push back against the Epic entities or risk a default under the agreements. Now, Your Honor, Medallion makes a lot of the fact that we say risk a default. But if you look at what the contract says, that was completely accurate. The contract says that in the event of a default, in the event of a material breach by Medallion, if there is a material breach, ARM needs to provide written notice, and the requirement for the notice is written notice as to the breach. We have to describe what the breach is. And a notice is just any written statement. Now, if after receiving that written notice as to the breach remains uncured for 30 days, then and only then does it become an event of default. You give a notice of breach, and 30 days later, if it's not fixed, it ripens into an event of default. And once it's an event of default, all you have to do is terminate with written notice. That's all you have to do. There's no interim step. So that October 5th letter started the clock ticking on Medallion's requirement to cure. And if it didn't cure, there would be an event of default and ARM would be able to terminate. Now, as it happens, Medallion acknowledged a performance default 8 days later. This is another letter from Mr. Lastman. He wrote it to Glencore. He said, Epic owes Medallion, Glencore, a 1 million barrel loading window per month. We know that they do not have that capability, so technically they are in a performance default. As to the WTL, he acknowledged that they had an inability to provide that service. Now, Your Honor, this email is just critically important because you recall the TRO and TI hearing where Medallion said that it was blindsided and had no idea what ARM's complaints really were, and that it had no idea that this was talking about a default. And this email, ARM didn't have this email at the TRO TI hearing. It was produced to us in discovery. Medallion did. And Medallion, who had Mr. Lastman at the beginning of that hearing, Mr. Lastman wrote this email. And Mr. Lastman, 8 days after receiving that October notice, said, yes, there is a performance default. Now, he also said that it's going to be remedied with the new doc in March of 2021 and WTL service in January of 2021. And although ARM did not receive this email, we did have regular calls with Glencore, and this was relayed to us. And just to be perfectly clear, we asked Mr. Lastman in his deposition, did you mean it? Did you mean performance default when you said it? And he said, in my opinion, at that time, yes. Now, Medallion went on to falsely claim that a cure was coming. Glencore wrote, was there any reply back from Epic on our substantial gripes? And Mr. Lastman responded, we're going to go meet with Epic, and we're not leaving until we get everything hashed out. Now, that wasn't true. Here's what did happen, and this is really suspicious timing. 3 weeks after we send the notice, Epic serves this, Epic does this revision to its tariff, and it drops a little footnote saying that due to prevailing operating conditions, carrier does not currently offer service under this common stream. Now, again, this tariff is not effective until December 1 of 2020. So that's 8 months of breach where there's a tariff that said that Epic can take this product, but ARM is being told Epic can't take this product. Medallion will not take this product because Epic won't ship it. And Medallion never changed its own tariff. Medallion's tariff says it's going to take Permian Common Stream 2. And Permian Common Stream 2 is still listed here as a WTL product. Now, on the question of whether ARM cared about WTL, we ask about it repeatedly. We ask about it in October. We're told wait until January. We asked in January. They said hang in there till January. And we asked about it in December. They said hang in there till January. In January, we asked, hey, can we do this in February? And they said, we cannot support this service at this time. Again, the clock is ticking on a cure. We keep getting representations that it is coming, and we're giving them some grace, but that it becomes apparent at some point that they are stringing us along. Now, this again goes to the notice point. Medallion knew full well that ARM and Glencore were so frustrated they were likely to terminate this contract. This is an email that Mr. Lastman sent to Glencore in December. He said, I highly doubt you'll exercise your option to extend the term of this contract. Medallion only had an 18-month deal with ARM, and Mr. Lastman was so aware of Glencore's frustrations, he knew that Glencore was likely to pull out. And here's another critical point. Medallion acknowledged it couldn't afford to let ARM and Glencore terminate. Here it is about the January WTL nomination. Mr. Lastman writes to Mr. Burney at Epic, ARM and Glencore have been stewing on this for several months. Again, they knew full well how important this WTL issue was. And he said, I tried to assuage them after their first complaint and hoped they'd go away, which is exactly what he tried to do. He said, I think they're getting killed so badly on the rate. And for the record, we are paying $1.50 for a service we are not getting, undisputably, as both the terminal and the pipeline capacity. He said they're looking for routes which we cannot afford to let happen. So Medallion knew full well, and this is January of 2021, that ARM and Glencore were poised to terminate. And so in February of 2021, they send us a purported accommodation on the WTL point. And here's what they offer. And Mr. Lastman testified that this was a one-time offer, that ARM would be able to ship 3,333 barrels per day of WTL, which was about 1/8 of ARM shipper pay obligation. And it would have commingled the WTL into the WTI stream. Now, again, this is a one-time offer to do 1/8 of what they said they were going to do. And we are months past the time that they were required to cure. This was not a cure. They are in default. This did not cure their default. They also offered an accommodation, quote unquote, as to the Suezmax. And again, this email, the two topics in this email are Suezmax service and WTL. The idea that this is some after the fact fabrication that ARM made up, this proves Medallion knew exactly what the issues were and that ARM was not happy about these particular problems. On the Suezmax point, he said, we will never be able to load more than 750,000 barrels at either the initial terminal or the new terminal that EPIC is working on. That's a shock. Everyone talked about promising a Suezmax. That was the promise. And now they're saying without apology, oh, we're never going to be able to do this. Now, they did say you can load your monthly shipper pay obligation, 861,000 barrels at a different terminal. Now, that involves extra costs for ARM, 10 cents a barrel for every barrel you move to the terminal. It was not the full 1 million barrel loading window promised. There were more restrictions at the other terminal, and we'll talk about that a bit. And again, the context of this was they just admitted that they could never do what they'd promised in their contract to do. This was not a cure, and a cure was long overdue at this point. And so, Your Honor, that is the breach, and I'm happy to take any questions about that or move on to the cancellation.
Go ahead.
All right, so ARM terminated in March of 2021, shortly after that email where Medallion admitted it could never perform. And it specifically said that in October of 2020, it had given notice, and Medallion had failed to cure the defaults identified in that notice. And just to give you a little timeline of all the representations, WTL service was supposed to start on April 1st. It got pushed back to June 1st, and they said, well, you know what, it's going to be in January. Nope, February, and in April. And spoiler alert, it didn't occur in April either. On the Suezmax point, it was supposed to be there April 1st. They said, it got pushed back to October. Okay, fine, we'll wait for that. Then March. And then turned out to be never. He told us never. So ARM has fully complied with its notice obligations. It complied with the letter of the contract. And it also, if you look at the Texas case law on notice, the touch point of notice is actual notice of putting the other side on notice of the issues. And we did that and more. And there is a robust record that confirms that they had notice. And these breaches were highly material. There is a 5-factor test set out by the Texas Supreme Court in the Mustang case. It adopts the restatement of contracts in this regard. And I just want to run through them. First factor, the extent to which the injured party will be deprived of the benefit which he reasonably expected. Now, Medallion's own documents confirm that Suezmax and WTL service were essential to this deal. Second factor, the extent to which the injured party can be adequately compensated for the part of that benefit of which he will be deprived. Here, the lack of bargain for functionality decreased ARM's ability to profit from this contract. It lost specific deals due to these limitations. And this is something that Medallion's really focused on, the agreements bar recovery of lost profits as consequential damages. It's not like we can say you didn't give us a Suezmax, so give us the difference in profits, the loss of profits we could have gotten between a Suezmax and an Aframax. The contract doesn't allow that. Our option is to terminate. We really have to terminate to preserve our rights. Another factor, the extent to which the party failing to perform or to offer to perform will suffer forfeiture. Now here, Medallion holds this space for free for a 30-year term, and it has successfully resold the space every month since we terminated. Another factor, the likelihood that the party failing to perform will cure. Well, Medallion repeatedly assured us that a cure was imminent. Those assurances were false and ultimately said it couldn't perform. Finally, the extent to which the behavior of the party failing to perform or to offer to perform comports with the standards of good faith and fair dealing. And here, there was no good faith by Medallion. It said to Epic, I tried to assuage them and hope they would go away. We got repeated and false assurances that this contract was going to get fixed, that a cure was coming, and it never did. So that, Your Honor, is cancellation. Do you have any questions about that part?
No.
So again, Your Honor, the story is ABC, really simple. There were agreements for Suezmax and WTL service. Medallion breached those agreements and ARM properly canceled. Now that ends our story, but I do want to talk about Medallion's story because I think you read the pre-hearing submissions where, they're very different. Medallion's story is all about distractions. And during this trial, you're going to hear a lot of them. You're going to hear 20 different subplots about issues that sound like they have nothing to do with the ABCs of this case. And you got a preview of that in their 56-page findings of fact, which really are a pretrial brief. There was a lot of argument in there that frankly is very hotly disputed. And I can only assume that the point of what Medallion is doing is to create enough smoke to suggest that there's a fire, to suggest that there's something more to this than the obvious, agreement, breach, and cancellation. But I assure you there's not. And really, when you hear things, in the case that seem kind of far afield from what we're talking about, the Suezmax promise, the WTL promise, those are distractions and they are designed to try to take everyone's eye off the ball from the obvious breach. I just want to talk through a few. One Medallion theme is their witnesses, and this is kind of a classic case of, everybody knew what the contract said until the lawyers got involved. Their witnesses have testified that they thought the contracts promised Suezmax service until we sued them. What Medallion said then, they were in a performance default. They acknowledged that. Now, and then this is Mr. Lastman. We asked Mr. Lastman, he said in his deposition that he changed his mind about whether it was a performance default. And we said, okay, well, when was that? And he said after. And we said, okay, what prompted that? He said, well, after I had a chance to review the agreement with legal. Same with Mr. Offit. He is Medallion's VP of Finance and Controller. We went through with him a presentation to the Medallion board where they said that they were going to get a Suez from Epic and sublease it to ARM. And he agreed. He participated in preparing that presentation. And we asked him now, so you'd agree, I assume, that one of the benefits to Medallion of the Epic agreements was having one firm window per month for a Suez tanker that could load 1 million barrels. And he said, well, in hindsight, I disagree with that. We said, whose interpretation are you basing your understanding on? And he said, it was based off my interpretation and legal counsel, internal legal counsels. And we said, is that an understanding you reached prior to this lawsuit? And he said, no. Second distraction, Medallion has an argument that the 1 million barrels descriptor in the contract describes the capacity of the terminal and not the vessel. Now, it's wrong as a matter of contract construction, and I will get into that in a minute, but really this is kind of a potato issue because Medallion admits that a terminal with a capacity of 1 million barrels is just one that can dock a Suezmax. And this is their CEO and their expert saying this. So on their best day, a terminal with a capacity of 1 million barrels, that's fine. It is one where you can dock a Suezmax, and no such terminal was ever built. And again, this argument is also legally wrong. The capacity of the terminals is defined elsewhere. And again, if you look at the promise under section 3.4a, the first part talks about the vessel that ARM is entitled to. The second talks about where ARM can load that vessel, at the initial terminal or the new terminal. And the third part talks about the kind of vessel that ARM can load each month. Each month, a vessel with a capacity of not more than 1 million barrels. Another Medallion theme, the idea that performance would have been impossible. Well, first principles, they've actually denied their claiming impossibility of performance. We asked them in an interrogatory, and they said, Medallion does not allege the affirmative defense of contractual impossibility. And this is really important. Suezmax service was entirely possible if only Epic had built a Suezmax dock. And this is data we got from their own experts data set. You can bring a Suezmax into New Star, and this is the inner harbor of Corpus Christi. You can bring it into the Eagleford terminals. Now, you can't bring it to Epic, but you can bring it to Valero right next door. It's two neighbors on either side can take a Suezmax. You can take it to Pin Oak, and you can take it to Buckeye. Medallion's real problem is that Epic just decided not to build this thing. Epic reached a resolution in December of 2020 after thinking about postponing for a long time, and they just said, you know, we're out of money. We're going to table this thing for a while. And it is still tabled. They have still not built this thing. But Epic's decision not to do that, and this is a key tenet of Texas law, Epic's decision not to build the dock is Medallion's problem. It's not ARM's. When you contract to render performance to produce a result, or to perform, you need the cooperation of a third person. You are not excused when that third person does not cooperate. That is fundamental. Medallion, under these contracts, obligated itself to do these things, and it is not ARM's problem that Epic didn't come through. Another distraction, there is an Exhibit B to the terminal agreement that states that all vessel loadings need to be dimensionally acceptable to Epic. So Medallion says, well, great, you know, Epic didn't build this dock, so, you know, obviously a Suezmax vessel is not going to be dimensionally acceptable to Epic. That is just backwards and crazy. And just as a matter of common sense, but also under Texas law, there is a specific promise in Section 3.4a, acknowledged by everybody involved in negotiating and signing this agreement, that ARM was going to get Suezmax service. The requirement in Exhibit B, kind of buried in the fine print there that you can see, is that the you know, whatever vessel gets brought in would have to be dimensionally acceptable to Epic. Now, if Epic had actually built the dock that it said it was going to build, it, the Medallion told ARM it was going to build, there would be no issue. And as a matter of contract interpretation under Texas law, Section 3.4, that specific promise, controls over general terms and conditions in Exhibit B. Specific conditions control over general. Provisions stated earlier in a contract are favored over subsequent ones, and no interpretation should render any promise meaningless. And Medallion's interpretation would violate all of those canons. It would wipe Section 3.4a out of existence. It would render it a nullity. It would basically mean that ARM got whatever terminal, if any, Epic got around to building. And that's just not what anyone bargained for. And that's not how the contract is properly construed. There's also a theme, and this is front and center in their pre-hearing brief, that ARM somehow caused Epic to delay the WTL connection at the SCM interconnect. Well, first of all, this is really puzzling, because as your honor saw earlier in this presentation, there are all sorts of origin points through which Medallion said it was going to be able to take WTL. And this origin point we're talking about is third from the bottom, SCM crude. It's one of 11 here. There is why Medallion thinks that this, you know, lack of service from this one terminal excuses everything else. It's just baffling, and it is also factually inaccurate. And I don't want to drag this far down in the weeds, but the fact is this interconnect was managed by an ARM affiliate who was actually out of the picture by July of 2020. And you know, the narrative about what actually happened there is false, but it's also so irrelevant. I'm not going to get into it in opening. The problem is, for whatever reason, Epic just didn't take WTL from any of these places. Another favorite Medallion distraction is this idea that ARM wasn't using these services anyway. And again, here's the point. Nominating at Suezmax or WTL would have been futile. The Suezmax dock was never built. And Medallion refused to accept WTL. You saw the emails. They told us repeatedly, it's not ready yet. Do not nominate it. We will not accept it. So nominating these items would have been an exercise in futility. And as I mentioned, nominations aren't costless. Vessel charters cost hundreds of thousands of dollars. And if you're going to nominate WTL, you need to actually buy that product from a producer and have it ready to put into the pipeline. And if you can't put it in the pipeline, you have to find some other pipeline for it, or you have to put it on trucks. There is no reason in Texas law, and this is a really important point, Texas law does not require you to perform this kind of useless act or idle ceremony. When someone says, I'm not going to do it, you don't have to do it just to prove a point. And this really kind of brought to mind, the kind of airline debacle that happened with Southwest this past holiday season. It's as if Southwest called its customers and said, you know what, your flight to Dallas tomorrow has been canceled. And the customer said, okay, please give me a refund. And then 2 days later, after the flight was to have occurred, Southwest said, you know what, we've denied your refund because you never showed up at the gate. How would we know that you were denied the opportunity to board? That is exactly what has happened here. And that's ridiculous. This is not how you run a business. This is not how you treat consumers. This is not what the contracts require. It's not what Texas law requires. There's also this notion that arms termination was a COVID-driven pretext. And again, I would encourage Your Honor to keep your eye on the timeline here. It is certainly true that between March and July of 2020, ARM, like basically everyone else in the oil and gas industry, certainly experienced difficulties. It was a dark time for everybody. But that was really in the early months of the contract. Now, by October 5th of 2020, things had really kind of turned around, but Suezmax and WTL service had not materialized. So ARM gave notice of its breach. Again, Medallion acknowledged the performance default and gave repeated assurances that the cure was imminent, and finally admitted that Epic would never be able to load a Suezmax. And so ARM terminates. And here, this is also really an important point for the economic pretext argument. ARM didn't just terminate, Glencore also terminated. Glencore was not paying the per barrel shipping fees that ARM was responsible for. Glencore, it was basically free shipping for Glencore, and Glencore still terminated because this deal was so bad. There were so many extra costs involved in the limitations we were getting that it wasn't worth it to them. Now, Medallion has also asserted a counterclaim, but this is just another money grab. Medallion has already kept, Mr. Stern mentioned this, $32.7 million of ARM's money. Prepayments that were never applied to any actual shipping. This was kind of a down payment that was going to get applied at the end of the contract, and $19 million in credit support. It has this money. It's had this money in its hands. It's been benefiting from this money, some of it since 2019. But yet it's asserted a counterclaim for more. This is baseless. This is baseless. Medallion breached, not ARM. The counterclaim should be denied. And so I want to go back to our story. It's really a simple story. A, B, C. And as we go through the trial, the evidence will show that the agreements.
You're way past your time. I've gotten the ABC. So is there anything else you wanted to touch on?
That, unless Your Honor has any questions, that is it from ARM.
Okay, why don't we do this? Why don't we take a short 10-minute break, and we'll reconvene in 10 minutes for the defendant's opening statement.